In this lesson, we will be considering judges. In terms of the three arms of state, that being the executive, the legislature, and the judiciary, the third, or the judiciary, has to be independent of the remaining two entities, that being the executive and the legislature. Thus, judges have to be impartial and independent and have a fervent tenor in order to distill justice or provide determinations of cases without fear or favor. Thus, this particular topic, we will begin by considering how exactly judicial appointments or how judges are appointed to various courts of law. At its inception, the LC or the Lord Chancellor was responsible for all judicial appointments along with the Department of Constitutional Affairs. However, as you may find out when studying constitutional law or public law as it is referred to in some syllabuses, the Lord Chancellor was part of other arms of state as well, thereby creating an issue as to whether he is completely independent, whether there is a conflict of interest that took place. Why this was particularly because the Lord Chancellor was considered to be a politician himself. However, after the Constitutional Reform Act of 2005, these powers of the Lord Chancellor were in fact taken away, and judicial appointments were bestowed upon the Judicial Appointments Commission, or the JAC. Now, the Judicial Appointments Commission in turn is an independent body. It's appointed by the Queen on the recommendations, however, of the Lord Chancellor. This can still be considered as somewhat questionable, but it is in fact more accountable than simply or merely giving power or authority of that nature to one individual, such as the Lord Chancellor. Now, there are various appointments that the Judicial Appointments Commission makes, including appointing of the judges below the Court of Appeal, the judges of the Court of Appeal, in which case it's appointed by the Queen on the recommendation of the Judicial Appointments Commission, as well as appointments to the Supreme Court done by a selection committee, the Supreme Court Selection Committee, which was established under that initial Constitutional Reform Act of 2005 I mentioned in the previous topic. Now, what's most important in terms of judges and the judiciary is that it is independent of both other arms of state as well as impartial in its decision making. Previously, politicians played a role in the appointments, as I noted, the Lord Chancellor being directly involved in appointing judges, thereby creating a political precedent. However, the Lord Chancellor can't appoint anymore, but still can reject an appointment based on his own reasoning. His powers have been limited by way of the Judicial Appointments Commission. One way of ensuring that a judiciary is independent, and in order to justify the statement that justice should not only be done but also seem to be done, there needs to be a lot of openness or transparency, specifically in terms of appointments that are made to the various courts of law. Moreover, as the UK has increasingly become quite diverse, with individuals from varying ethnicities, countries, religions, it becomes necessary that the composition or the makeup of the judiciary is also as diverse as possible. You see, the composition of the judiciary has to be more than just a similar group all the time. It has always been, specifically in the UK, known to be the stable of elderly, white, educated, elite men. So this composition has to change, and in order to do so, there must be also a diverse community backing, as in, much like the Judicial Appointments Commission, having to select judges based not only on their competency, but how diverse their ethnicities and backdrops are as well. Moving on, it is also important in order to maintain this independence, so as to make sure that judges are not influenced in any way, that they are immune from suit. And what I mean by this is that judges should be free to decide on any matter without the fear of being prosecuted themselves for the decisions they make during the time in office. The normal removal processes in play are firstly the retirement age, which is 70. They have to be secured their tenure, and the removal is now governed by the Constitutional Reform Act of 2005, which stipulates that above High Court level, both houses of Parliament must get involved in order to impeach a judge of a court of law. whereas below the High Court, the Lord Chancellor will remove based on recommendations from the Lord Chief Justice. So there is a consultation process in play as well. As a whole, the judiciary is not only entitled with determining cases, but also it is involved in dispute settlement, sentencing, judicial review, case management, and various extrajudicial activities. One of the most notable inclusions into the UK's legislature has been the Human Rights Act of 1998, and it has had a significant effect on the judicial structure of the UK as well. Judges have to now decide in line with the HRA of 1998. Therefore, when interpreting statute, it has to be in accordance with the HRA as well. Wherein it is not in accordance, it is the duty of the judiciary to put Parliament on notice when a statute or a particular law is not compatible with the HRA. The effect of the Human Rights Act of 1998 also extends to the principles of stare decisis or precedent. That was a brief outline on judges. In the next lesson, we will consider Article 6 and the due process.